Good afternoon, everyone. My name is Christian Senolf. I am the Stakeholder Engagement Manager at RECA, and I will be your host for this town hall, the moderator. I want to start off by thanking all of you for joining us today to delve into phase 2 of part 2 of the rules review. I know your participation both through the online survey and through this town hall is extremely important, and we appreciate all of the participation. It's playing a pivotal role in shaping the future of the industries that RECA governs. Today's agenda is very straightforward. I will begin by providing you with some background information on the rules review, and then I'll follow that off by going through the discussion paper. Throughout the presentation, I encourage all of you to ask questions as they arise. I want to foster an interactive discussion here, so every time we go through a particular question that is asked in the discussion paper, at the end of that, when I pose the question, please give me your feedback in the chat option that you have available through your Zoom Q&A feature. What we'll be discussing today are proposals. They're created by the industry councils through the Rules Review Steering Committee. Nothing here is final. There's absolutely no decision that has been made so far. It's a consultation. I just wanted to reiterate that the proposed changes will afterwards need to flow through the industry councils all the way up to the Minister of Service Alberta. So this is just consultation. Nothing here is final. I want to now introduce the steering committee, many of whom are here on the call with us today, and express my sincere gratitude to all of them for the work that they've done. The dedication and effort that they've devoted to this project does deserve special recognition, and I want to thank all of them. I'll start off with the chair of the steering committee, who's sitting beside me here, Mr. Neil McCrank, and I'll give him an opportunity just to say a few words, and then I'll give everyone as well on the call an opportunity.
Well, thank you, Christian. First of all, thanks very much, everybody, for agreeing to allow me to sit in on this gathering. I know that you've been meeting regularly for the last couple of years, trying to update your rules, trying to make them more consistent with the public interest. And that's, of course, the role that I play, having been, as many of you on the list would know, Terry in particular. I spent a long time in government, now retired, but asked to come out of retirement to chair this gathering to make sure that everything is in the public interest. And I can tell you so far from what I can see, you people have the public interest in mind in everything you do, and hopefully that will continue into the future. I will not be participating in this discussion today unless asked to do so specifically, because most of what you're dealing with is way beyond my level of understanding. I'll have to understand it a little better before we sign off in the final analysis. But at the moment, my purpose is a watching brief. I want to make sure that when we get to the point where I have to sign off to the government that everything is in the public interest, that I've had some involvement in it. And knowing the people that are on that list, many of whom, as I say, I know that this will be in the public interest. So thank you very much for welcoming me and allowing me to sit in on this meeting today.
Thank you so much, Chair. I will go off by the list here that I have available to me. So Keith McMullen, who is from the Residential Property Management Industry Council. I'm not sure if you want to introduce yourself, but please do.
Oh, thank you. Yes, I'm representing property management, and we're here to get everyone's feedback because there's a lot of work still to be done. Thank you.
Thank you for that. The next one I have here is Jason Bamblett, who is on the Residential Real Estate Industry Council.
Good afternoon, everybody. Jason Bamblett at Remax House. I'm the vice chair of the Industry Council for the residential members. And thank you to everybody that's participating today.
Thank you, sir. The next one we have is Gord Apparel, who's actually was unfortunately not able to join us for this call. The next one I have there is Sherry Long.
Yes, I'm on the Commercial Industry Council, and I do thank you for your time today to give you feedback.
Don Brown, you're next on the list.
Thank you, Christian. Yeah, I'm Don Brown. I'm one of the elected members of the Residential Property Manager Industry Council, and I hold one of the condominium management seats. Condominium management is one of the newest license out there, and of course, the rules are very near and dear to us. So we appreciate everybody taking the time today to come out and give us the input. The feedback is important. Thank you.
Thank you for that. And then regrettably, the other two members were not able to join us today. One of them is Laura Sharon, and then the other one is Ben Van Dyck. They are Laura's from the commercial property management, and then we have Ben from the rural agribusiness. So they are not able to join us for this call, but we'll move forward without them. So there's also members of the industry council on the call, and at this point, I think we'll move on with the presentation, and then they can always, if they have anything they want to say afterwards, we'll give them an opportunity to do that as well from the various industry councils. So the slide you see here in front of you gives you a brief overview of what has happened over the past, I guess, almost 18 years since the rules came into force. So the last changes that took place were, as you see, they're not very major changes. There's been a change in 2006. When they came into force, that's when they first came into force. In 2008 is when designated agency and transaction brokerage came into force for real estate brokerages. 2014 written service agreements became a requirement, and then in 2020 the condominium management came under RECA's authority in terms of regulating that industry. So there haven't been many changes since the rules came into effect in 2006, and that's why this it highlights the importance of what we're doing right now. This gives you a brief overview of what we went through in terms of process. First, there you see phase one is when RECA went out to 1,500 stakeholders and asked them for their opinions on the state of the rules review, on the state of the rules and how we can improve the rules. Though the feedback that came from phase one was used in phase two. As you see, phase two, because it's such a big task, was divided into 3 different parts. Part 1 dealt with licensing framework, part 2 dealt with standards of practice, and part 3 is going to deal with accounting and document retention. Currently, we are in part 2. And then the final part of the review is the final consultation with stakeholders, phase 3, where after everything that you have provided has been incorporated into the recommendations that the steering committee will make to the industry councils when they form their final decision in terms of what changes will take place. All of those changes will flow back through the initial stakeholders from phase 1 for their sober second thoughts, is what we like to call it. So that gives you a brief overview of the structure. Moving forward, again, something I touched on in the introduction, but all of these are just proposals for consultation. They're coming from the Rules Review Steering Committee, and nothing here is final. We're just seeking your input in order to allow the steering committee to have a better understanding of where industry stands on a lot of these issues. Thanks, Brian. So moving over to diving directly into the actual meat of the discussion paper. So we have the first question here in front of you. It has to do with Rule 41, and I'll just read it out for you and then we'll open it up to questions. So should Rule 41 provide examples of competent services to enhance enforcement mechanisms, increase public protection, and to ensure licensees possess the knowledge, skills, and abilities necessary to provide services, to give appropriate advice, and to comply with fiduciary duties? This is just to give you a little bit of context, the rationale behind this is that currently competent services is fairly broad, the way it's structured in the rules. It doesn't have any prescriptive examples, and including a little more meat to that section would allow the hearing committee to better form opinions when they're trying to determine whether somebody actually did provide competent services. So it gives them a little bit, it makes their process a little bit easier. So we'll go over with the questions here that I see. I'm wondering if it's looking like the proposed changes will go through regarding if you want to open a brokerage that only sells residential, that the brokerage then only needs the residential. So I assume that has to do with the licensing structure changes that was initially discussed in part 1. As of this point in time, I don't think there's any firm answer.
I don't think, sorry, just to introduce myself, I'm Warren Martinson. I'm the registrar here at RECA. In terms of the licensing structure that was being discussed, the steering committee has made some recommendations that incorporates a single license with various authorizations under that. I think, Graham, the question you have, if you only want to sell a broker, or if you only want to open a brokerage that sells residential, would that be possible? That's what the steering committee is recommending that the councils consider, where individuals can pick and choose authorizations in the various 7 sectors under one license. Nothing's been decided on it, obviously, and there's going to be further consultations. So I don't think it's going to be within 6 months or probably even 12 months, because, Graham, if there's going to be any changes in relation to something like that, I think the steering committee and the industry councils would probably want to give industry a pretty long runway in terms of preparing for it, and then try to incorporate something in and around the licensing period in our typical licensing year. So more news at 11. Stay tuned, and we'll be having further discussions about licensing structure as well.
Thanks for that, Warren. And moving on to the next question here, Dana. I'm not sure if we want to address this question at the moment, because the intention here was to focus on the various, somebody just joined, the question as they're posed in the discussion paper to get more clarity on the questions we're posing right now. But I can definitely circle back to this question and have a discussion with you about that. Kickbacks, it will be difficult for the regulator to really make rules around that, because it falls kind of outside of our scope. But we can definitely have a more robust discussion about that after. Thanks for that, Brian. Now, is there any specific questions that relate to this part of the discussion paper that we're talking about right now, about introducing more prescriptive sections under competent services, essentially examples of what constitutes competent services? Are there any concerns with that? Okay, hearing none, moving on to the next one. So the next thing we have here in front of us is, should the rules be amended to include a licensee's legal obligation to a customer, providing further protection to the public? For example, an inclusion of a licensee must fulfill their legal obligations to customers. Currently, we do have a mirror of this as it relates to clients, and the suggestion here is to include an addition that actually establishes that requirement in the rules. What does competent services mean? We have agents driving 4 hours to sell properties outside of their port. Lorne, that's a really good question. I was actually up in Edson today or last week doing their AGM there, and a similar question got posed. And it's an important question. I think that competent services, as it's currently outlined through the rules, is as long as you have the education, if you have the education, you have a license, and you're deemed to be competent. I think if you include a little bit more additional sections under competent services to provide examples, you could allow hearing panels to have some recourse in terms of if they want to sanction someone for not providing competent services, because currently it's a broad term, as you indicate. The hearing panels are made up of one member of a licensee, an industry member, member of the public, and a legal person, a lawyer. And sometimes it's tough to articulate what competent services is. I see Warren wants to step in and provide.
Well, I think competent service is one of those broad topics like negligence is in the common law, that competent service will be determined really on a case-by-case basis in terms of what the individual's experience is, how long they've been licensed. Competent service, part of competent service is knowing when you're not competent, when you don't have the answers. And so to your example, Lauren, if agents are undertaking work in markets that they simply don't have any knowledge about, then that does potentially raise issues of competence. One thing that I think Christian and the other regulatory compliance advisors try to stress with everyone that they talk to, and I know members of the industry council as well, is is understanding your own limitations is really critical. So, you know, lawyers deal with this. When I was in private practice, you know, there were areas of law that while you have a law degree and you're a member of the law society, you're really not competent to answer them. And so understanding the limits. Lauren Raquel also mentions definition of competence is too generic. That's what part of this question is. Should we supplement the broad, because the rules, for example, can't possibly have every possible example, right? And so the idea is there has to be an overarching competence rule. The idea here is as we see more cases, or if the industry council sees particular practices that they want to highlight, then the industry council can include those. But I don't think we're ever going to get to the point, and I don't think it's really a great idea to totally have a prescriptive rule, because there's simply no way to write rules that can accommodate every possible outcome. And that's why I mentioned negligence, for example. There are textbooks, courses that are given on what is and is not negligent, and there simply isn't a way to get so prescriptive, because something's really going to fall under the that we're just not going to be going to have one that's prescriptive enough.
For sure. And the issue raised about somebody driving 4 hours to show a property, I think previous to the unification of some of the boards, where now you have access to the MLS data regardless of where you are in the province, it was more easy to make the claim that somebody isn't providing competent services because they don't have access to that MLS data. But now with access of the sold data, and with what's on the internet right now, a person that lives in Calgary could technically provide competent services to somebody buying a property in Red Deer. They will go online, search the neighborhood, figure out what's a good neighborhood, what's a bad neighborhood, look at the sales data. I mean, they have the skills needed in order to evaluate whether that property is a good price or a bad price. Now, I know the argument can be made that having more focused knowledge of a particular market is better, but the competent services is a threshold. Once you pass that threshold, it's difficult to make the claim that they haven't provided it. So there's a lot of questions that came in here. So I'll start with Elena Kutz. Including more in the competence section is a slippery slope. Keeping it broad allows for more discretion at the hearing panel level. As long as they meet the broad level, that should be of the necessity for verbiage. It also holds licensees accountable. So that was something that actually came back as a consequence of hearing panels not having enough direction when they're trying to assess an issue of competence. That's why this suggestion actually came in, because of what they've seen at hearing panels not having enough direction. So I agree with you, discretion is important. I think Warren touched on that, but I don't think what is being proposed here limits discretion. It just provides some prescription of what competence is, and it will leave it open for additional consideration at the panel level. Next one there, we have licensing framework, previous town hall meeting. There was several questions asked, and we were all advised that we would be supplied back with the answers to the questions, as there were so many. RECA is doing a process to say the process is being carried out as government to what we're being advised. RECA not corresponding at all with members. So those questions were answered, and they are on our website, to my understanding. I was actually involved in answering those questions. They are there on our website. Jeff, if you want, I can provide you with a link. Definitely reach out to me, and I can provide you with that and have a more robust discussion about what your issues are there. Len Lane, perhaps it needs to be supplemental course.
I think that's Len was just talking a little bit about once the rules get changed, perhaps there can be supplemental education on some of the prescriptive things.
A great comment. Thank you for that. Rule 41D, not all clients have different needs. This should be detailed in their personal contract and expectations and not broadly defined by the rules. So good.
And I think that, Steve, that's part of the reason why competent service is somewhat generic, is that everyone's needs do differ. And every licensee is going to be faced with different circumstances. One of the examples that's used in the legal side is a doctor that comes to the side of a road and finds an individual injured. Well, the doctor is going to be held to a different level of competent standards having worked in an emergency situation on the side of the road. And so competence is also going to be defined as well by, you know, length of time in the industry, what their education is, what type of practice that they have, how much experience. A lot of times people can say, well, I'm not sure how to define competence, but I know it if it's incompetence.
That's right.
So, you know, sometimes we have, there are individuals commenting that they may be working on a type of transaction, whether that's a really sophisticated commercial transaction or working in the agribusiness sector when they don't have a great deal of experience in that.
Thank you for that, Warren. Yeah, so and it seems like the other questions that are being raised go in the same vein of maybe not restricting it or not providing more prescriptive definition of what.
And I think Brett, your comment as well at the bottom, that's nice. Thank you very much for having that as well.
And this is what we're looking for. So thank you. I think that was the intention of the steering committee, to get your perspective on whether more is good. Now moving, it seems like we fell back to the first question, but focusing now on this one that's in front of you, should the rules be amended to include obligations, legal obligations to a customer, providing further protection to the public? Like I said, there is a section in the rules when it relates, as it relates to clients, the obligation is established there. Do you see value in including an obligation for consumers or customers?
Maybe you can just speak a little bit, Christian, about the difference, like what this is trying to get at, the difference between clients and customers.
For sure. So as a client, you owe to your clients, you owe fiduciary obligations, obviously, not only from the ones that exist in common law, but also the ones that are outlined in the rules and the contractual obligations that you have through the service agreement. So when it relates to a customer, those obligations are less well defined. So the intention here was to just include something more robust in the rules. Again, so that hearing panels have a little bit more, it makes their job a little easier in situations where somebody hasn't met their obligations to a customer.
Any comments on this one? Well, we'll circle back if there are, if people are thinking about it.
Thank you. The next one you have there is undermining.
Oh, I'm sorry, Steve, you said your initial comment was for this one.
Steve, 21D, note all clients have different needs. It should be detailed in their personal contract.
Okay.
Oh. But how does that relate to customers though? I guess we can take that offline. We'll take that offline, Steve, just and we can have a discussion about. Yeah, thanks. So the next one that we have on.
And just before we go on is Maureen, I think a reasonable realtor. I think that reasonable is kind of. I agree with your point. It's kind of subsumed in the issue of competent service. One would expect that competent service would meet a reasonability standard. So, but thank you very much, and that's precisely what the standard is in the example that I used, like negligence.
Thank you, Warren. The next one you have there on your screen has to do with 41 and 42G. So should the obligations to demonstrate good character be placed on the licensee under Rule 41 to complement Rule 42G? That a licensee must not engage in conduct that undermines public confidence in the industry, harms the integrity of the industry, or brings the industry into disrepute. So some background to this, 42G has a higher threshold. So 41 would be a lower threshold in terms of when it's going through a hearing panel. And it also aligns, because RECA currently has a good character policy, it would tie that policy to a particular rule in the rules. In terms of giving you some context as to why this was suggested to be included.
So that you know, section 41 is sort of a positive obligation. It says licensees must. Section 42, licensees must not. And right now, G is in 42. So the thought is, does it make any? Should some of these rules be phrased in the positive rather than the negative? I'm not sure if it has a great deal of difference.
So from what I understand, the threshold is a little different in
Okay.
terms of 42G has a higher threshold. 41 is a little bit lower of a threshold in terms of when it's presented to a hearing panel. So it would make a hearing panel, it would give the hearing panel a little more flexibility in determining whether somebody, if somebody has not demonstrated good character. And it also ties it to the good character policy that we have.
And thank you, Tracy, for your comment about the consumer relations guide in relation to the to customers.
Yeah, that's a great point. The only, I guess, thing that was in addition to that is that they wanted somehow to tie that back to the rules.
To the rules
consumer-
explicitly.
Yeah,
Okay.
consumer relationship guide is a contractual thing, but thank you for those comments. So if there's no comments on this one, I guess we'll wait a little bit. If not, we'll move to the next section. Please, yeah, provide your comments as they go, and then if we need to, we'll circle back. So next one that you see here in front of your screen, service agreements. Should a licensee who establishes a client relationship when trading in real estate or dealing in mortgages be required to enter into a written service agreement, provide a written service agreement with the client prior to providing services? So to give you more context here, I know most of you know Section 43 already exists. There is a requirement to enter into a service agreement, but that section doesn't delineate specifically when that needs to happen. It's clearly, we understand it has to happen when the relationship escalates from a customer to a client. However, that section isn't very prescriptive when it comes to that. So the intention here is to introduce language that makes it clear that a licensee has to enter into a service agreement at a specific time to add more clarity. Okay. With Stacy, customers always have the option to go into an exclusive agency. Okay, it's good. Thank you for that comment. Thank you, Brett. David Page, the consumer relationship guide defines the customer is and what a client is, of course, defines. Thank you for that. Yeah, so it seems like consensus, or from what we've seen so far, is that there shouldn't be any inclusion of that. I know that the steering committee will be happy to see that. Who determines what this is? Gary, what are you referring to?
Yeah, Jerry, maybe give a little bit more detail, and then we can circle back. And thank you, Diana, for posting consultations.
And then the second part of the question here that you see on the screen is, when dealing with self-represented consumers, should a licensee be required to provide a customer acknowledgement prior to providing services? I think that is implied in the way we interpret the rules. When people come to me with questions regarding this, myself, Doug, and Gary, we've always indicated that you need to provide that consumer relationship guide to them and the customer acknowledgement. But the intention here is to enshrine that in the rules. Any specific questions related to any concerns, comments?
And again, we can always circle back
Okay,
if
you
because
got it.
people are thinking about
Yeah.
it on the go.
Absolutely. We'll leave it open at the end. There's a question period as well. Is unpopular political or social position in appropriate context? You see, that's a really good question, and I don't want to take that on, so I'm going to let the registrar.
There can be, I think what's been enunciated in the past is there can be conduct that occurs outside your direct licensing activity that can raise issues of does it bring the industry into disrepute. This is a common section across professions that I've seen. The Law Society has it. I know healthcare professionals have something. I hate to give you the lawyer answer, Jerry, but I think it really depends. Obviously, as a regulator and looking at everyone has freedom of speech and the ability to make a comment on political or social issues. I think it would depend on the nature of the comments, how they were directed, to whom they were directed. Were they on your letterhead as a licensee? Were they made purely in a personal capacity? But again, personal conduct can become the subject of disciplinary action. Again, if it is of such a nature that brings the industry into disrepute.
Thank you for that, Warren. Nathan has a comment, I believe, yes, service agreements are important, but the big problem with establishing what a service agreement needs to be or when it needs to be entered into before providing services is that there's no opportunity for the agent to show value to their potential client. So I think the issue there is you can have someone in customer status showcase your value at the inception of the relationship, and then once you start providing advice, that's essentially the point in where you transition from a customer to a client. When they're starting to ask you for advice, when they're divulging confidential information to you, those are triggers to us to have that conversation about, listen, you've taken these steps. Now we have to talk about the fact that what is happening here could be implied agency. We need to sign a service agreement. So you could still provide value to them without having a requirement to enter into a service agreement the moment you meet them. So I don't think that's what's being suggested here. I think the suggestion is to be more prescriptive about when a service agreement actually needs to be entered into. Because right now there is, the section is a little ambiguous when it comes to that. But I don't, from my time at the steering committee and the discussions that we're having there, I don't think that their intention was to require licensees to enter into a service agreement the moment they meet someone. You can certainly deal with them as a customer, build that relationship, and then when it's time, escalate. We have Elena next. My side of this industry does not deal with self-rep in general, but I do believe adults should be able to adult. If you do not fully understand to what end is a license required to ensure they fully understand the situation, I would not want to encourage someone to sign it if they don't comprehend. Yeah, and I agree with you there. Again, the intention there, I believe, is not to have a consumer relationship, like that consumer acknowledgement. That's not a requirement for them to sign it. It's a requirement for the licensee to provide it to the customer. And I think that's the way we've interpreted the rules so far. But the intention here is to make it a little more clear within the rules instead of just the interpretation.
And I think licensees giving individuals the opportunity to ask questions about those documents. Obviously, a licensee can't, determine whether someone fully understands it. People are generally presumed to have capacity unless it's proven otherwise. And so having a discussion about what's contained in the document and allowing the person to ask questions, I think is important. But you're right, Elena. There's only so much that licensees can do to ensure that individuals understand what they're signing, and a lot again will have to do with how it was expressed to them, whether the person had a chance to review it. And then also this is, I think RECA would probably also say it would be good to have notes on what you discussed in your files, so that if there are allegations after the fact, that there's some memorialized record as to what you did.
Absolutely. I'm going to butcher your name. I'm really sorry. I don't know. Giedre. We are seeing an increasing number of so-called wholesalers or developers without licenses approaching homeowners and making offers to buy their homes. Flyers, direct approaches, and calls seem relentless. Will anything be done about this? I've had a large influx of those questions as well, and there's limitations in terms of what RECA can do if the wholesalers / developers are purchasing the properties for themselves. They're exempt under the Real Estate Act, and we essentially have no authority over them. Now, if they're licensees as well, then there might be some recourse that would be available through the good character or putting the industry in disrepute, depending on what exactly they're doing. If they're really badgering consumers, but if they're developers and they own the corporation themselves, it's very hard for RECA to get involved. Warren, I'm not sure if you want to add anything to that.
Yeah, I think everything, when we look at these things, everything turns around what the definition of licensed activity is.
Yeah.
And to the extent that an activity falls under a licensed category, we have jurisdiction. If it doesn't, then we really don't.
Absolutely. Brett, regarding establishing a client relationship, often clients are a bit guarded when first meeting with an associate. It's not until a dialogue occurs with the associate that services, advices are given. I don't think it's fair to expect the licensee associate to stop a conversation or showing to put a contract in front of. And I agree with you here entirely. I don't think this would be what's being suggested. Again, in a situation where you're showing a property, that itself does not require, it's not deemed to be a trade. If you're showing a property only to a prospective client, there's actually an exclusion section in the rules that specifically crystallizes that as an exception. So if all you're doing is showing a property to a prospective client, you would not be required to enter into that service agreement. Again, I think the first few meetings, there's no issue. It's what happens. The situation that's a problem is when somebody doesn't sign a service agreement until the time the offer is actually being written. Which I guess there's a comment right below that says exactly that. I can guarantee you that probably 78% of exclusive buyer rep agreements in residential real estate are signed by the buyer at the time of the offer. Exactly. And that's the issue, because there's clearly an agency relationship before that buyer, the purchase agreement is signed. There's, they've been dealing with that person for a long time until they get to, most times. Certainly there's situations where that happens quickly. But in most cases, there's a client relationship beforehand and there isn't the appropriate service agreement in place. So that's what this rule, what the addition to this rule is trying to change. Marguerite, she agrees with Brett, and hopefully that provides some clarity to you. The intention isn't to require you as a licensee to enter into a service agreement the minute you meet the person. That's, again, that would not match the practical reality of what happens in industry. And the people on the steering committee operate in industry. They're very, very aware of that. A friend mentioned that if an agreement is signed and this person then uses another realtor, their signed buyer agreement is useless. I think we could take that offline, but I disagree with that. I think if you have a signed service agreement, then you could use that if you wanted to recover commission, if that's what they're worrying. It depends on whether the other party has indicated that the realtor has committed something that forced a breach of the contract, because sometimes there's provisions in the service agreement that say what can terminate the agreement early. If those things have happened, then the agreement could have been terminated early. They can provide notice to their agent saying that they feel they materially breached their obligations and they're canceling the agreement. So there's a number of ways, but I think my email is on the website. Definitely email me or call me. We can chat more about that, because that's a little bit outside the scope of our discussion today. I too agree with Brett. Perfect. I too agree with Brett, and I agree with Brett too. As someone who traded industry, I don't think that's what is being proposed here.
I think one of the interesting things that's being suggested though in the questions is looking at the timing of these things, that trying to pinpoint when these things should happen. So thank you very much for the feedback, because again, like every interaction you have with the client is going to be different, and nothing really falls neatly into black and white lines a lot of time, and that goes to Nathan's comment, I think too. What do you think of price X? And then so again, it's the drawing of lines can always be a bit of an issue, and I think that's why maybe the rule is being suggested to try to do a little bit black and white. But if the timing becomes problematic, that's certainly something that the committee should take into account. And maybe there's a better time to do it, or something else that can be done in conjunction with the consumer guide. But so thank you for that. I think the committee will definitely consider these timing issues.
Thank you for that, Warren. And my advice on these issues always has been that there's a trigger. The two triggers are confidential information from me and then asking for advice. So if they're providing you confidential information, if they're asking for advice, and there, as you see, what do you think of this price? To me, that would be a request for advice from the person. So in a situation like that, if I were in that position, I would be escalating from a customer to a client. But I guess that's best practice. Dale says, would it be fair statement to state that once you move the process to looking at potential sites is when the service agreement should be created and signed off? I think that's, again, the triggers that I would highlight are release of confidential information, and then also asking for advice. Setting up a search, I don't think necessarily meets that criteria. It could, but I don't think it's sufficient, but not necessary. So yeah, we'll move over for that. Thank you, Brian. consumers, client relationships and acknowledgement should be an absolute prior to providing services. The responsibility of the realtor agent relationship with a client or customer is fully and adequately defined and therefore triggers and can be identified, and the client customer will understand the requirements to sign a service agreement. If there is a removal of responsibility or accountability of the realtor, then the agent is the licensing and insurance of competency of individuals. Then what good is the licensing and insurance? Okay, very good point, Dave. And I think we saw that in the comments to this question, that there's kind of two views on this. One that's okay with getting them signed early and one that's not so okay. Thank you for that. Dale Norland, further to my question, I feel that the service agreement with the client and the agent does create the obligation relationship of the client. Yes, absolutely. Implied agency is still in effect in Alberta, but we do need to ensure consumers understand that the consumer relationship guide should help with that. Yeah, absolutely. Dale Stewart, I've always educated forcing buyers. Forcing buyers to sign an exclusive service agreement is like making a person who walks into a department store buy something before they leave, and they can't buy from anywhere else without paying the original store. With regard to the non-exclusive agreement, you would think buyers would already understand that realtors are getting payments for our services, even if it's not from them. Always been my opinion. My opinion is always not a waste of paper. I wouldn't say that. Thank you for that submission and comment, Dale. What about misuse of the forms by realtors, having to sign a buyer agreement to get access to their website? Yeah, that is something that we see in industry, Maureen, but I guess some of it is a requirement, I believe, especially if there's sales data being provided to them. It's part of the requirements from the MLS directly, that it's not just made available to anyone. So, but if you want to chat more about that, send me an email. A crazy question. Has any of the panelists had past profession of real estate agents or mortgage brokers dealing with clients to feel that we go through walking in an industry member's shoes? Yeah, so all of except the chair are members of the industry, of the various sectors, the 7 sectors, the industry that RECA governs. So they're all members of industry.
And in terms of this panel, Christian, you've worked in industry.
Yeah, for over 10 years, absolutely. I've never had a buyer lament that they want to sign a contract.
I think just a good comment.
Yeah, thank you. Read my last comment. The issue of having to get the agreement signed prior to providing services is that if you only show a few homes but don't give advice, aka services, then the agent suggests a meeting at their office or their home or Zoom or whatever to sign a buyer rep agreement. The agent is clearly doing the right thing. The problem isn't on the agent side, it's on the consumer side, where they already think of the agent as their realtor and has already been providing services. So their response is typically, why are we already working together? Why do I need to sign the contract? So these are issues that you can address very clearly by just providing them more context in the requirement under the Real Estate Act rules, by differentiating between customer and client. If they're asking these questions, I would imagine that they're not understanding those concepts very well, and that's why they're asking those questions. They're just looking for a little more information. So if I were in your shoes, I would use this as an opportunity to add value to them, to the relationship, by showing your deep understanding of the issues here.
And I agree, Graham. You know, the issue is going to be training and experience, and hopefully the work that a broker can do with new agents. You're right. I think that it's critical that licensees don't look at pre-licensing education as the last of their education. It's always you're always going to be learning, but I appreciate the comment. If there are things, Graham, that you think that we can do either through if it's not through the rules, and I agree with you, the rules are kind of an imperfect tool to use, a mechanism to use in order to do this. The rules are just one thing, but if there are other things that RECA can do, please, you can reach out to the industry councils, or you can reach out to someone here at RECA in terms of how do we better through publications or or even at some point in time through relicensing education to give to enhance people's skills in this area.
Thank you. I think that was great comments, great discussion. Thank you for that. Moving on to, oh, is there something else? Oh, I feel that private mortgage activity should require a brokerage representation like in Ontario, and that a service agreement at or before a formal application and consent is completed. In Ontario, a private lender is only able to advertise if through a brokerage or if they are properly licensed. I feel the same should be in Alberta to ensure consumers are dealing with confirmed lenders and must accompany a service agreement. Very good comment, Danielle, and we have members from the Mortgage Industry Council here that I'm sure are happy that that you posted it. Different as was required. Okay, thank you for that comment as well. So moving on to the next question here that we have. In the interest of transparency, a licensee provide client if licensees provide client information to third-party service providers for the purpose of referral, should the licensee provide notice to the client and collect the client's consent, provided that consent must comply with the Personal Information Protection Act. Rule 45 prescribes how a licensee may share the personal information of a client with a third-party service provider. So that deals with referral disclosures here.
This might also speak to a little bit to the condominium question about third-party providers,
Yeah.
and the sort of disclosures that have to be made towards in the event that that there are connections between service providers and licensees.
Yes, but if condo corporation uses a third-party technology app for communication with residents, I don't think we need active consent from owners. And I don't, that's a great point, Dana. I think what's the situation here is if you stand to receive a referral is essentially what,
Like a referral fee.
yeah, which realistically there is, we have a rule, section 45 of the rules does already deal with this, but I guess this will extend the obligation slightly in that currently you have to notify that you stand to receive a referral. I believe this is taking it a step further. Some tech apps sell services to residents. RECA should do an audit of all people named and shamed in the RECA regulator as to their level of extra designations they have, such as CCS, and how many extra voluntary courses they have taken over the years. Probably a correlation to extra courses, skills versus breaking the rules. Just a thought.
I think what we've done in the past is that where individuals are claiming specialized knowledge that if called upon, they should be able to demonstrate what it is that's underpinning this extra expertise. I think that's
yeah.
all.
Yeah, if you have issues with someone that you think is claiming that they have some sort of extra designation or they're providing a certain service that you don't think they need, you can send a complaint to us and we will investigate. As Warren suggested, the advertising guidelines are clear that you have to be able to substantiate any claims you make. So if you're claiming that you're a specialist, there has to be a way for you to substantiate that. So if you have issues with that, send us an email. If it's found the perpetrators have essentially no extra courses or designations, then I'd say that makes a pretty good argument that getting a license is still too easy. So the license is one component of it, but the extra designations are another, right?
Yeah, and there are different professions that offer different designations, and again, we're always trying to walk that balance on the pre-licensing education, to trying to hit that balance. Is it enough that people get a start? But it's certainly not, as I mentioned before, pre-licensing education certainly isn't the end of someone's education and learning and growth in any profession.
Tracy, this might also speak to providing the terms of buyer's contract to another buyer in multiple offers. As the terms of contract are provided for the purpose of purchasing a property, not for the purpose of negotiating another contract with the buyer's term. Is it a violation of the Privacy Act as well? It's a good question. I think most of the times when that's done, the purchase contract is redacted to remove any confidential private information in that document. But you raise a really good point, Tracy, and I think that unfortunately it kind of falls outside of RECA scope because you're doing that on the direction of your client. It's not that the licensee is taking that action. It should be done on the direction of the client, right? Absolutely. But if you want to chat about that offline, definitely give me a call or text me, whatever is easier. I just wanted to focus on the question at hand here. But adding another document to gain consent for third parties feels like a change of direction from the red tape reduction ideology. Perhaps this just needs to be okay. So just to clarify, Elena, that's a really good question you have here. So currently we do have under section 45 of the rules, there's a requirement for a licensee to disclose to a client when they're forwarding the information to someone. But that disclosure doesn't require client consent. So essentially what this is doing is protecting you as a licensee because you know, it says realistically, you're going to have to comply with PIPA anyways. And this is just building what's required in PIPA into the Real Estate Act rules. Because if you don't get that consent, even though it's not in the rules, if you don't get that consent, then a client can come back afterwards and say, you didn't get my consent to forward that information and file a complaint with the Office of the Privacy Commissioner. So this is just trying to tie those two together. But your point is well taken.
Well, and I think it also if it may also just give an expectation, not that a lot of your clients are reading our rules. I'm not going to be so naive as to think that, but having this as a requirement, it maybe gives just more transparency. But the Elena, the feedback is good, and I'm sure the committee will take that into account and similar to those other comments about people debating of, you know, the timing of the customer agreements or the relationship agreements, that those are very very useful to get back from you.
Thank you for that, Warren. And Tracy, again, very good comment there. I've heard different views on that from different legal counsel in terms of if you're making an offer, whether that's confidential information, since you are making that offer to the seller. And that's why the seller has the ability to share that information with other, but we can discuss, that's the multiple offer question. That's something that's beyond the scope of this question. So I just want to make sure that we have enough time. So moving on, I guess, is there any more questions pertaining to this particular question that's being asked about requiring client consent when making referrals? Currently, there's a requirement on the licensee to inform the client that they're referring their name to someone else, but this is asking if there should be required consent. So essentially what happens now is you can just send an email to the client saying, hey, I'm forwarding your information to this service provider. I might get a referral. Now what's being suggested is to have some sort of correspondence where the client says that's okay, so that you could keep that in your file. Doesn't have to be signed. It could be just a response to the email or a text. Okay, so with that in mind, moving on to we can circle back if there's questions about this. Unlicensed activity by support personnel. Should Rule 46.3 and 4 be removed in the interest of red tape reduction, as unlicensed activity by support personnel is sufficiently addressed in Rule 46.1 and 2? This is, I think, fairly simple question. It's essentially a clerical change in a sense.
Trying to get get rid of a little bit of duplication.
Absolutely. Any questions on that? If not, then we'll move over to the next one. Thank you, Brian. Advertising standards set by the brokerage. So while RECA believes it is important for consumers to understand the brokerage the licensee is registered with I'm sorry, I got to rip it. While RECA believes it is important for the consumer to understand the brokerage the licensee is registered with, should rules and guidelines related to the requirements for clearly advertising the brokerage name be amended to allow more brokerage flexibility? Essentially, just to summarize it, currently we have an advertising guideline that dictates what brokerages can do. Should that be amended to the point where the brokerages set their guidelines internally within the brokerage. Yes, it should be removed. Thank you for that comment.
Sometimes the comments on this too, Christian, differ depending on whether we're speaking to a broker or whether we're speaking with an associate.
Very true. Second, okay. Definitely circle back to that if there's no, or maybe you're typing away right now. What are examples of flexibility? So the examples of flexibility would be allowing the brokerage to make the determination. I don't know, Warren, if you could think of more, because currently right now the advertising guidelines are set by the regulator. And the question is, should we, in the interest of red tape reduction, should we put that obligation, that onus on the brokerages? It would allow for more flexibility so the brokerages can be a little more innovative, but it could also open up a can of worms as well. Yeah, oh, somebody said that, Audrey.
And really, I guess the question, where this is coming from is while brokers always have the ability to manage their advertising, sometimes a rule like sometimes the guidelines can help because it puts everyone on sort of an equal playing field, and that's maybe where Bill, Mr. Terabane, is coming from.
Yeah.
As well as Jeff, I see we need some conformity.
Okay. David.
Although David says, let's just make this plain and simple a broker decision. That's another valid point. And Alan, no, there should be governing rules, even playing field, how many brokers are advertising specialists. Thank you for that, Alan. It's
so it seems like it's kind of split in the middle.
well, yeah, there are a few more on keeping
Yes.
them, but it's definitely something that these questions and the discussion will certainly help the committee and the industry councils and the industry council members that are sitting here, sitting at this, attending this meeting, can also take it into account when they're looking at the rules on this. And again, there's going to be much more consultation, not just in the rules context, but issues such as advertising guidelines and how that works. That's also always things that we want to hear back from licensees. So if anyone has comments on that, don't feel that it can just be done through this forum. Please let us know if there are any other things on advertising.
Absolutely. One thing to say is that I really value the fact that the steering committee has decided to ask these questions that sometimes create, some opposing views, because that's what it's important here, to just ask these questions. Leave it alone as it okay. And Dale says some brokers have no idea what their agents are doing and have no desire to police their agents' advertising. If it isn't policed, it will be abused. Thank you for that statement, Dale.
I see some heads nodding on the call as well.
Still think the public needs to know where to complain.
Yeah,
That's a really good point.
Thank you,
for that. We're doing more internally on that. Absolutely. Thank you for that. If there's no more, we also need to keep in mind, this is meant to assist with ensuring Albertans understand the advertising. So by allowing my flexibility, does it make it easier for the public to understand what they're engaging in, or does it make it harder? That's a very good point. I see where you're coming from there.
I think, Elena, it depends largely on the editorial skills of the broker, but I see your point. I hope all brokers, their basic aim is to communicate in a way that will be understood. So
the client will know the brokerage when they enter into a service agreement. Until then, it's just marketing, advertising. I don't think the consumer is at risk by opening this up a bit.
thank you,
Good
Brett.
point. Yeah. More flexibility. Yeah, no problem at all. Thank you. Thank you for that. So I guess we'll move over to the next issue. Thank you, Brian. The next question. So payment of brokerage commissions. Should the payment of commissions or other remuneration under Rule 50C1, 66C1, and these are just the different industries that we regulate, so the 4 industries, do more than one to more than one corporation of which a broker, associate broker, or associate owns no less than 50% of the shares issued by that corporation be removed more flexibility for payout of brokerage. So just to give you context right now, as a licensee, you can only receive a commission or remuneration personally or to a corporation of which you have at least 50% ownership. The question here is, should that restriction be removed so that you could have 20% ownership, 10% ownership, whatever ownership you have, you could still get your commission paid to that corporation without issues. I think this, one of the drivers here is that sometimes in real estate specifically, there's very large teams where a team might have a corporation, and this would allow that team to get paid into that corporation. Tracy says no.
Tracy, maybe you can give a little bit more depth. The one thing that an example came up, for example, the example is a licensee has a family-held corporation that has the licensee spouse, and one of the licensee's children. And so if the licensee for tax purposes wants that commission paid to the corporation, then the rule currently wouldn't allow that.
Mm-hmm.
And so I think the mischief that this rule is trying to address is you don't want unlicensed individuals acting in a capacity that they need a license for.
Yeah.
And the thought with proposing this, was that we can still police unlicensed activity while still allow licensees to tax plan. Tracy, thank you. The brokerage should
Right. Brokerage should only, the licensee for the paper.
licensee should only pay, the brokerage should only pay the licensee for the,
Property?
maybe we can offline that,
Yeah.
Tracy, and have a further conversation about it. Okay.
I think it's meant to give more flexibility and remove some of the red tape. But if there's particular issues that you see with it, definitely let us know on it. Then there may be possibility to pay corporations when all stakeholders are licensees.
That's true, David. There are people that may have, like a group of licensees may have a corporate structure that they work through as well.
And I think to Warren's point, the mischief I was trying to correct can be circumvented easily by just different, because corporations can have different shares. So even though you might not have 50% ownership of the corporation, you could have B share so that you could flow the money to regardless of whether you have 50% or not. So it's not really preventing it either way.
And I think, Alan, what you're saying is so would that company carry the license or the person? I think if this rule went away, the person would still carry the license. I think any investigator, what they would look like, so you follow the money. If commissions are paid to the 1234 Alberta Ltd, then the question is going to be, was 12345 Alberta Ltd doing anything that requires a license?
Mm-hmm.
Is the payment of a commission the only thing? This is kind of similar to what I was used to in the insurance sector, where in order for there to be a problem, you had to have, so you could pay commissions to any unlicensed entity. The issue that arose would be if that licensed entity appears to be engaging in the practice. So does that numbered company appear on your letterhead? Does it appear on any of your agreements with the clients? Rather than simply there's more to, we'd look at more to what that numbered company is doing in order to determine whether or not it requires a license.
Thank you for that, Warren. The problem becomes who else, person A who was licensed and person B who was not, person C, and how would you follow the paperwork who actually did the work?
I agree, Alan. I think what we need to do is look and actually see the documents, ask the client, well, who was it that you spoke to? And if all of a sudden we start finding out that person B and person C who aren't licensed are actually having the discussions with the client, then from our point of view, where it's paid is less of an issue. They're undertaking unlicensed activity in any event.
Thank you for that one. Great flexibility, reduced red tape. When the one with the license is a 50-50 split with a spouse for income splitting in the corporation, this would require this will require change in percentage. Where is the harm in this?
Thank you,
Yeah,
Dale,
thank
for
you,
that
Dale.
comment. We'll keep that on the list.
Consumers don't care if an agent takes payment to their corp or even less so what the corp structure is. If it is the associate who holds the license and represents the consumer, a customer, not the corporation, changing this rule on payment of commission would not impact the consumer. Yeah, it's a very good point.
Thanks
Brett.
for the
Thank you
feedback,
for the
Brett.
feedback. All can be investigated as needed. There you go.
Thank you, David, for that feedback.
Thank you as well. And I guess, thanks. Oh, I agree with Brett. Thank you.
Everyone's agreeing with Brett
Yes.
today.
Brett. Thank you for that. I guess we'll move over to the next question there. Brokerage oversight. So under the rules, a broker must be actively engaged in the management of the brokerage. Should examples of the standard of being actively engaged be provided to increase accountability, to enhance public protection, and to improve enforcement mechanisms?
Maybe deal with that one first.
Yeah, and then we'll go to the next one.
So I guess the question here that the committee would like to get the feedback on is how prescriptive should the rules be in defining what actively engaged is? And it can be a bit of a difficult exercise, but hearing back your feedback, I think the committee would really appreciate. Should there be
Yes, I know so many brokers were not actively engaged. Thank you, Alan. That's a good point. Yes, I agree with this. As long as duties can be delegated, yeah, the delegation will always be available. It's just adding more color to what it means to be actively engaged. Thank you for that.
And I guess this is another one of those times when we know what active engagement is when we see it,
Like
but
open
it's hard to define, eh?
Exactly. And I think from what I gather from this, it would help hearing panels to have some meat to the rules so they know, they have an idea. It doesn't have to be exhaustive, like you said, Warren. It's more of just having a better understanding of what is perceived as oversight, as proper oversight.
This next one may get some
Pushback?
get some more, not put, no, I'm looking for feedback because I know thank you, Terrell and Yusra.
I think it's a folly to try to define this too much. There's different brokerage models and technology, and broker could hire great staff and managers. Thank you for that. Yusuf Jochma, the federal government shows two types of correct docs. Red times for wrong and green check mark indicates correct. So a better template of right and wrong. Sure.
Yep, more having something more prescriptive. I think Yusra, you're saying that can assist.
Yeah. Would this be seen as targeting cloud-based brokerages? I don't think there's no intention to target anyone. I think all business models are welcome. It's just about including a little more information on what being actively engaged is. Thank you for that, though. To what end, though? If I'm doing my role and my company is doing just fine, why would RECA need to be part of the conversation? I can see this as a bit of overreach. And Elena, I agree with you. If you're doing your job correctly, I don't think that's going to impact you at all. I think it's meant to give, again, what I touched on earlier, just hearing panels more direction when trying to determine whether the broker in a particular case did provide proper oversight.
However, and again, to Elena's point, and this is just as valid, does the current rule work?
Yeah.
And do you need to have additional, like a rule that says broker must do this so many times, and
Yeah, if you think it's too prescriptive, then that's fine. I think that one other aspect of that, though, is that sometimes if you have more prescriptive definitions, then you're not leaving everything at the discretion of the hearings panel. So you can argue that both ways. Sometimes it can work in the benefit of the licensee as well. They can say, well, I did meet all the requirements. Brokerage oversight, question 2, does this not suggest the creation of obstacles to fair competition? So we didn't get to question 2, but I'll read it out for you right now. So question 2 is, should there be a limit on the amount of licensee a broker may supervise, manage, or alternatively, a limit on the number of transactions a broker may supervise, manage to ensure effective oversight? And something that was discussed as well on this issue is that sometimes clearly if you're supervising a very active team that has a lot of experience, you might not, the number might differ. So there are definitely additional limitations to this, but guess Diana, you mentioned that could, oh, sorry, David. David, all licensee agents should have their own brokerage license within 3 years of being originally licensed and take full responsibility for their actions. Thank you for that, David.
I think Bill was talking about the previous question. Thank you,
Yeah.
Bill, for the comment.
Okay, thank you, Bill. Alan, no, depending how many times a broker has had investigations for their brokerage. If not investigations, no limit. Okay, so no, okay, so I guess you're looking at how they're performing and then determining whether a limit should be imposed.
Yeah.
That's a good point. Agreed with David here. Thank you for that, Dale.
And Tom, thank you.
Yeah, thank you for that comment as well. Brokers are already totally responsible for everything in the brokerage, so I'm not sure whether this would be helpful. If you aren't getting the support, then go to another brokerage. Thank you for that.
Thank you, yeah.
Keep it the same. I have high tech and can handle many with lots of oversight. Thank you, Steve.
That's a good point, Steve, that as technology changes, the amount of people someone can supervise is different. I think part of the other reason why this question, there are other provinces that have put limits
Yeah.
on the number of individuals that one person can properly supervise. But again, it's very prescriptive and to Christian's point, the amount of supervision that 20 people with 25 years of experience needs may be substantially different than 25 people. So numbers aren't necessarily the answer, but we wanted to make sure that you had the ability to give us feedback on the question.
Thanks for that. And to your point as well, I think BC has the 200. Is it 200? I think they put a limit in terms of how many they can manage. Tyrell, brokers and brokerages should be empowered to run their business how they feel. Thank you for that comment. They all become associate brokers within their brokerage and responsible for all of it. Okay, thank you for that, David. Regarding question 2, not if they have the staff to manage it. Thank you for that. No limit, agree with Steve. It seems to be a consensus here. Thank you for that. Tracy, I think this is an overreach. If the brokerage is doing a good job, why would RECA be able to change the business model? Thank you for that, Tracy. Very good point. Len, no question, associate broker in the mortgage industry would be a great thing. Thank you for that, Len. We're coming to that shortly. No limits of agents for lead broker. They can run their offices. Thank you, David. RECA annual audits and findings are a great tool for how well brokerages are doing. As well, when a number of associates show up in case summaries from said brokerage, then perhaps RECA investigates the engagement of the broker. An associate has to be licensed under a broker. If there are issues, then RECA should be doing corrective measures. There are a great number of brokerages and brokers out there that should be allowed to grow. Thank you, Jeff. That's a very good point. A brokerage is not run just by a single broker. Many of the big ones have layers of support / technology. I've not seen enough disciplinary action taken against brokers to feel this is a genuine problem. Thank you, Brett. Great point. So there seems to be a consensus building. And yeah, if there was a limit, it would be for the benefit of the agent, not the broker. Broker are hard to get a hold of and get an answer from in these big mega brokerages. I would know. That's
I've heard that from some of the licensees on some of the councils as well, that sometimes it's tough to get a hold of brokers.
Thank you for that. Very good discussion. Thank you for that. I guess we'll leave it for now. We'll move to the next one. If anything else comes up, we can circle back to it, or definitely send me an email. Promise to pay commissions, referral fee. Do payments and receipts of referral fees. The referral fees need to flow through the brokerage. So currently there are requirements in the rules that referral fees must be paid through the brokerage, and they also must be received through the brokerage. And the question here is if that should continue to be the case. We got some more comments here. You get what you pay for. I really not like the proposed rule will make referral fees even easier to facilitate. In the public interest, I request that RECA make it more difficult for referral fees to be facilitated by condo managers or condo management brokerages, perhaps to the point of making them illegal. So you very good point you're making here is that the rules can be catered to different sectors. That is something that's available to the various industry councils. So I'm sure the representative from the condo management side will be looking at that.
Thank you for that comment. You know, there are some jurisdictions, I think, that prohibit the payment of referral fees.
Yeah.
Other jurisdictions do not. And so it's definitely something that different provinces have certainly taken a different approach to it.
Yeah.
But it seems like there's a lot of support for referral fees going through the brokerage here.
Or not going through it.
Or sorry, do they need to go through the brokerage?
So,
Yes.
so they
Yeah.
should be flowing through the brokerage. Okay, perfect.
Yeah.
My bad, Warren.
Thanks, everyone. Well,
Thank you. I agree with Len. Okay. What if the referral payment is from a carpet company or something not directly related to, I guess if it's related to a trade in industry, if the referral is coming to you as a consequence of a trade that took place, then that would have to flow through the brokerage. But, you know, there's an interpretation component to that as well. So maybe we can take that offline. We can chat more about it to get more specific as what exactly happened.
I think this comment from Daniel is regarding mortgage
As well?
associate brokers. So
It should be required once the brokerage a specific number. Thank you, Danielle. I know Clarence is on the call, so you'll be looking at that for sure. Okay. Guess that was a fairly easy one. Moving on to the next one here we have transaction brokerage and personal deals. So I'll open it up with the first section there. Should the practice of transaction brokerage be discontinued as it has in some provinces or has been limited in some jurisdictions?
and again, this was simply just a question to get a bit of a temperature check from industry. So any feedback, again, there's, you know, no decision, not even a predisposition that I've heard from industry council members. So getting some feedback here would be really appreciated.
People are probably busy typing away right now.
I think so. Yeah.
There's a lot of opinions here. So I'll just wait a second. I'll read the second question and we'll see if they start coming in. So should licensees be prohibited from representing another party while representing themselves in the same trade/deal? I know that there's some opinions through my discussions with licensees and brokers that this is currently the case, but if there is informed consent, it can happen. So the question here is, should we have something in the rules that expressly prohibits it, even with informed consent? Question 2, there's definitely a conflict of interest. Yeah, absolutely. And that's the issue there, is that you can get past that conflict with informed consent. And the question is, should we include something in the rules to essentially prohibit it? No, this would end double-ended deals. Yeah, so Alan's referring to the first part. This would hurt our ability to find the right property for the right person. If I represent the property, but also represent the right buyer, then I cannot represent both. Yeah, that's essentially what would happen. Tracy, not unless there's a strong evidence of misuse. How many complaints on this have we received? Well, Tracy, that's a good point. I don't know the actual number, but from what I've seen, sometimes in industry, the consumer doesn't really even understand what's happening from what I've seen. But in terms of complaints,
Off the top of my head.
yeah, it'd be tough for us to say, but it's definitely not a large number. Dana, yes, absolutely. You would not believe how many condo management brokerages own handyman services or plumbers or pest control companies or restoration company. This is not disclosed to the condo corporation.
Would that be to the last question regarding referral fees?
That would be to the previous question. Thank you for that, Dana. That's a really good point, though. Something that we need to consider in the discussions coming forward. Nathan, no, a common law agency brokerage would be massively hindered by this. How many instances of misrepresentation have been investigated in regards to transaction brokerage? Again, I don't have the hard data on that, but my assumption is that it's not a very large number. Dana, this about it. If the management company owns the restoration company, what incentive is there to act quickly to attend to active leaks?
That's a very good point, Dana, and about definitely about managing conflicts of interest.
Yeah.
I think light is probably the best antiseptic, and that's why disclosure is so important. That there's nothing in and of itself wrong with necessarily wrong with certain conflicts of interest. The real issue is disclosing it properly so that the individuals understand what's going on, and if they feel that something is not being handled properly, at least they have the knowledge then of the conflict.
Absolutely. And if there is an informed consent, you can definitely come to us. We would investigate that. Bill's point, I feel many agents do not understand being a facilitator. That is something that I've heard from other brokers as well. Next comment there, we have multiple offer scenarios are extra challenging when there's also a component of transaction. Very valid point.
Mm-hmm.
That is something that has come to my attention as well.
And we have, I've heard in the last little while, there are discussions about obviously about how to handle multiple offers and yeah, if it's a transaction, it adds to the complexity, that's for sure.
It adds a layer to it for sure. Agreed with. Also, Tracy says the seller is asking the licensee to sell their property. Why should this be limited? As long as disclosure is done properly. And that's a good point, Tracy. That's a good counterpoint. Disclosure is the key issue there, making sure there's informed consent.
Thanks, Tracy.
I agree with Tracy. Thank you, Nathan. No, if it's handled properly and by the book, it can be done. And at times it is of essence with some of these deals. That makes a lot of sense in rural settings. I have been doing these for years and have not had any issues with it. Thank you, Corey, for that.
That's not an uncommon sentiment, Corey, that we've heard from industry.
From industry as well. Thank you for that. And thank you everyone for that robust discussion on that issue. That's very helpful. I think we'll move over to the next question. Brian, please. Oh, transaction brokerage should stay. We have a good framework and a clear forms for this. Few consumers complain about this. Second, licensees should not be able to represent themselves and another party in the same deal. I believe RECA does not apply in this instance, and RECA could follow suit. This would make our industry look good to the consumers as well. Thank you for that, Brett. Very informative comment. We have a conflict of interest if we have two buyers interested in the same property. I think realtors can explain the conflict of interest, but a realtor buying a property from a buyer should be supervised. Yeah, thank you for that.
Thank you, Maureen.
And moving on to the next question here that you see on your screen. Should the responsibility on brokerages to validate the information they're collecting and submitting to lenders be strengthened to enhance consumer protection and improve fraud detection? This is aimed at members from the mortgage industry.
So part of the discussion that came up on this was there's a rule that says that you should document what, if any, steps you've taken to validate information. And so the question that was asked, and for those of you that are attending from the mortgage broker side, this was one question that Gary Siegel, one of our regulatory compliance officers, wanted to raise as well with the committee. Gary is a longtime industry member, and then was also president of AMBA, and was a council member, has been here. So the issue was, right now the rule says that you should document what, if any, steps you've taken. That kind of raised the question, well, should you be required to take steps to verify, which is a bit above what the rule currently says. So anyone on the brokerage side that's attending, if you've got some comments on that or would like to give us some feedback, that would be very appreciated.
And David says, like BC, I believe he's referring to transaction brokerage, like BC, each buyer and seller have their own representation. That is correct. They've removed transaction brokerage in BC. There's only exemptions in limited circumstances where there isn't a sufficient number of brokerages to broker the deal. they allow it in those cases, but in most large urban areas.
Well, and you know, it's something that I know that the committee members and Mr. McCrank and council members have said in conjunction with the rules review that whatever comes out in the rules, it has to be flexible enough to deal with our rural environment.
Mhm.
So I know many of the council members have been really focused on that question.
Yeah.
Because you know, not everyone is in
Urban
Calgary
area, yeah.
and Alberta or and Calgary and Edmonton.
Yeah.
So validation.
Becomes a slippery slope. I'm sorry, you.
Oh, no, go ahead.
Validation becomes a slippery slope for the lender. They sometimes think we may be coaching the employer. At your auditor's request, we add into all submission notes that documents have been reviewed but not verified. Thank you for that, Len. Mortgage brokers already are required to verify ID. Lenders also do their own due diligence. The lawyers do theirs. Thank you, Sue. Know your broker to ensure name, address, date of birth, copies of their IDs, all matches, B equals credit bureaus, pay stubs, etc. Yusuf, thank you. I'd say it potentially confuses buyers on the roles and expertise of brokers, agents, and mortgage brokers. We can check and verify what we can, but it is up to mortgage brokers, banks, as the experts in the field. Okay, thank you for that comment.
This it's also timely, you know, the FinTrack has announced that mortgage brokers are now going to be covered by the same sort of FinTrack obligations that other licensees have already been subject to for some period of time. So this issue on collecting and submitting or sort of the validation that licensees do is timely in that respect.
Absolutely. Thank you for that. I guess, Brian, move over to the next one if there's no more questions here. We're moving a little faster than expected, so we'll have some time for more questions at the end. Should a mandatory relationship be established when a licensee is managing an individual private lender, and if so, under what circumstances? So I guess to give you more context on this as well, currently the RECA information bulletin concerning being an agent for a lender states that mortgage brokers who work with individual private lenders must represent the lender and treat the borrower as a customer. This guideline is not reflected in the rules. As the prevalence of private lending increases in Alberta, more and more licensees are finding themselves working with particular private lenders more often. So this is meant to correct that and align what's in the information bulletin with what's in the rules. Include something in the rules that aligns with what's in the information bulletin.
Well, people are typing, you know, private lending is a really interesting area because not only that we hear that it's increasing in use, but it's also anecdotal.
Yeah.
And it's, you know, it's very difficult from a regulatory point of view to get your finger on exactly what level of private lending is going on out there and what levels and so and someone earlier on mentioned the Ontario license where a mortgage broker can't act on behalf of or can't act with a private lender unless they take an additional course that get, and then they get an additional authorization on their license that they can act with private lenders.
So Lorraine there says Rule 72, we already gather pay stub letters of employment, bank statements, and search websites. We do not call the job to validate employment, but the lenders are doing that. And on the bank statements, all we can do is review the statements for any discrepancies, as the bank will tell you nothing. It's a great comment. Thank you. The WSA covers that, I thought. Use the I represents the lender, not the customer. Thank you for that point. Anything else on this? If there's something, oh, I think it should be encouraged, but not mandatory. However, I think that both borrower and lender should receive a disclosure confirming whom the brokerage is acting for and in the best interest of. That's a very good point.
Thank you, Daniel.
Thank you. So we'll move over to the last question there, Brian, and then we'll open up to questions for all of them. This has to do with condominium management and regarding orderly transfer between condominiums. So should these proposed rules be implemented to regulate the order transfer from one condominium or property management company to another before the management agreement terminates? And in the discussion paper, you would have had a little bit more detail in terms of what they are, but I have them here. I can read them out to you. They're not on the screen, they're part of the notes. So stakeholders have advised RECA that orderly transfers from former condominium or property management companies to current ones do not always occur promptly, and that there needs to be something in the rules to correct this. So for regular transfer, RECA suggests the following inclusion in the rules. The current management company must transfer within 10 days of request from the new manager the following information: the list of owners, including names, address, and in some cases, mortgage lender. Legal description of each unit, unit factor for each unit, current trade people, and contact info on pad agreement. RECA, so the second, for disorderly transitions, so transitions that are not, I guess, amicable, when a manager is released for cause, the above information must be transferred within 24 hours. And everything else within 10 days. In either an orderly or disorderly transfer, all funds must be transferred to the new condominium manager on the day of transfer. That all GICs must be in the condominium corporation's name and not held in trust. So those are just some of them, some of the, I guess, suggested changes. Oh, we have a lot of.
Yeah, Dana has a good list. Here's the list that should be going to the that the outgoing management broker should provide.
Okay.
All the documents that fulfill section 20.52 of the condominium property reg, owners lists, including civic number, etc., current vendors list, most current EFT report, signed PAD forms, and draft for half operating account. And then Dana also said, as of right now, there's a lot of tension when there's a management transition, because as he will not stop asking for PAD documentation that's still provided. When management companies contact their own lawyer for advice, they find out that they do have to send PAD information to the new management company, because that was only gathered. This is a really good, interesting point, Dana. Thank you. Is that the PAD information was gathered for the benefit of the condo corp. So the idea then, I think what Dana is pointing to is if the condo corp is that the old management company doesn't have any more reason for it, or has no reason not to give it to the new, because it's provided for the benefit of the corporation. That's a really good point, Dana. Thank you.
Thank you for that, Dana. Steve says electronic transfer must be available on that list. We have taken on several properties and some have insisted on paper only. Thank you for that comment. That's a really good point. Marguerite, yes, the outgoing management broker should provide all information. Thank you for that. 24 hours is too short, and that's only for transitions that are deemed to be disorderly. And I'm not sure if we have a definition of what that.
Yeah, I think there'd have to be a little bit more. But thank you, Alan. Like you're right, 24 hours can be a pretty short period, because we're also having to deal with, people on vacations, and there are some condo management companies have different capacities than other. That's obvious too. So thank you, Alan, for that feedback.
There are far too many issues with the proposal as it went out. There is a lot of flaws and quite a bit that just are not viable. Thank you for that. If you want to reach out to myself, I can transfer that information over to the appropriate industry council, or reach out directly to the industry council, whatever's more convenient for you.
Thanks, Elena.
It takes at least 2 to 3 weeks to open bank accounts, set up software, etc. Thank you for that, Steve. And ATB can open a bank account within 20. Oh, well, a lot of time descriptions of the units are not available. I agree, 24 hours is too short. Thank you for those.
This discussion sort of reminds me what I was told, that when you get a group of condo managers together, you're definitely going to have a number of different opinions. So it's good to see the feedback, and I know that the Don who's attending will really appreciate all of this.
Yeah, ATB can, and they're awesome. Our software is US based, however, and takes some time. I understand that there may be some drama around previous management firms, but understand that the condo corp is still under a contract until the end. Meaning, no, I'm not sending funds to a new manager when it is still my liability as the current manager. Thank you for that.
I guess, yeah, it's just trying to balance that with what the condo corp is requiring,
Yeah.
because you're holding on behalf of the condo corp. But yeah, Elena and I have had that conversation before as well. So thanks Elena for raising it so that we have it on the record here.
And more to that point, if you're being directed by the client to perform an action, would there even be liability, since you have been directed by the client to transfer the funds?
I think the question that comes up once in a while is, there are a number of different obligations under the agreement. So if you're being told to transfer funds, that's only one of the issues.
Okay.
I think the concern was that there may be other things that the manager is still on the hook for. And I think Elena's point is how do you balance that, where yeah, the board wants to do something, but at the same time the manager may still be responsible for certain things. And I guess trying to paper that is the difficult thing. So no, I do get I understand precisely Elena's point on that.
Thank you for that. And it appears that we are at the end of the question, I guess, of the questions we're asking through the discussion paper. So we're going to open it up to just general questions.
Anything else that on the questions that we haven't dealt with, or if anyone
You have some questions in the chat, Brian? Are those okay? People just do okay. I guess they couldn't see that, but that's okay. Thanks.
Well, we did have some extra time, so if to the extent that people have new comments or suggestions after hearing the discussion, please feel free to contact us. And Brian, can you maybe just restate how people can get Alan said
Arrears the condo board carries. If I transfer the money, they will default on their bills. Very good point.
yeah,
Something
that
to
goes
consider.
to Elena's point. And then Brett said, I don't think RECA should wait too long to address the licensing framework. Allowing agents to be licensed at more would allow greater specialization. Yeah, the discussion, I think we're trying to come to some conclusions on that. Again, the big thing is going to be implementation and giving individuals enough time to address. And Brett, if you have more comments, it would be great to hear more comments from you. If you want to reach out to us about this issue of being allowed to be licensed at more than one brokerage, providing each brokerage is in a different sector. There's been some willingness to maybe look at that. The committee did in principle suggest that if you're in unrelated sectors, being allowed to have a license at different brokerages. But then I think the complicating factor is, again, we want to make sure something doesn't cause a problem for rural brokerages. So maybe allow the registrar to have some discretion to issue licenses at different brokerages within related sectors, just to make sure that that communities can continue to get service. So, Brett, thank you for that. The contact
Yeah, we'll provide the
info.
contact info. Yeah.
Sure.
We can include that. Can we include the contact info for like myself, maybe Warren, in the chat? Back to the corporation question, why is there an issue with the 50-50 split when the shares are with a spouse and a real estate associate? So in that situation, there would be no issue, and what they're trying, the change there is to actually remove that requirement so that there's even more freedom. Yeah. You can maybe respond back if, so there's no issue with that. If you share a corporation with your spouse, currently there's no issue. And the suggestion is that you would move away from that so that if you wanted a corporation to include maybe your children, you could have that. So you can only have a 25% ownership stake. Your wife can have 25, and then you could have 2 children, 25 each, and it would still work. Thanks. So no reason to change. Well, the reason to change is that currently you're limited to that 50-50 split. So you have to have at least 50%. If you have less than 50, you cannot receive the commission of that corporation. The change will eliminate that and allow you to receive it even if you own 25%.
But again, if you think things are working fine the way they are, Dale, that's a perfectly reasonable feedback to give us as well.
Abby has, when it comes to transitions for condominium managers, the verbiage is currently most times corporations transition to new brokerages will also transition bank accounts, therefore requiring new pre-authorizations to be set up for those accounts. At the request of the manager, I would recommend 10 days after the final day of the previous management contract. If the new manager asks for the information 3 months prior to the transition, it could become outdated by the time the transition occurs, therefore duplicating my work. Okay, that's a really good point. Sorry, this verbiage, the current manager. Okay, yeah, thanks for that, Abby. Don says oversight. Oh, sorry.
I think that's about, yeah, measurements. We'll take that back. Thank you, Don.
Yeah, thank you, Don. David, accountability on buyer brokerage agreement is needed as most agents may still be signing them at the offer stage only. Like a listing, no homes should show until buyer service agreement signed. No more, I don't need that, and I can show you houses without it.
Oh, that's
a very good, interesting
point, David. Thank you.
David. Yeah, thank you for that. I guess you're taking the suggestion even further than what was being proposed.
Yeah.
I'm wondering if there's a concern with transaction brokerage as it exists. It seems to work fine. Would be my comment. Has there been consultation with BC regarding their change? Not official consultation in that regard, but.
Well, I think we hear from time to time, but it does, Lauren, it does raise a good point that we should check and see what their experience has been there. Similarly with British Columbia bringing on the for instance, the registration of teams, that's something else that we seek feedback with BC to kind of say, what was it that you were trying to get at and what has the experience been? So we'll be talking to our colleagues in BC about that. But thank you for also prompting us to talk to them about their experience with transaction brokerage.
Thank you, Warren. Corey says that is going to be very confusing for the public, handing out different cards for different brokerages and different fields with the same realtor. I thought we were trying to. That's a very valid comment, Corey. Thank you for that. I agree with Corey. Thank you, Tracy. Email addresses for owners should be included in the transition list for condominium transfers. That's an interesting point. Thanks, you, Abby. Me too. Thank you, and. It's less confusing because there would be fewer services on the card the consumer receives, depending on the. That's a good counterpoint to that, Brett, in the sense that you could be specific in which industry you're trading. So, Jeff Taylor, associate should only be licensed under one brokerage. If the brokerage does not offer what the associate interest is, then the associate go to another brokerage. Different cards for different brokerages, not good. And Jeff, that's a good point, great point. And I guess just to clarify, what was being suggested would still allow brokers to not allow that through their policy procedure manual. It essentially moves the needle.
Yeah, brokers edit, regardless of if there's a sectoral approach to to licensing. It really will be up to the broker to decide one way or the other. And you know, we currently, let's not forget, we currently have licensees that may, for example, have two different cards, because
Absolutely.
we have individuals that are in the mortgage sector, that are also, for example, have a real estate license,
Absolutely.
not doing any real estate really, other than maybe property management,
Mhm.
or the only reason they have it is so that they may have better access to MLS and things like that.
And some of them do trade too.
And some of
actually
them do
sell real
trade,
estate
yeah.
And mortgages at the same
So,
time.
we currently do have individuals that have multiple licenses, or multiple authorizations with different brokerages, and so we're dealing with that disclosure issue right now. But thank you.
David says, with Vancouver board saying 35% of agents sold nothing last year, how can this be called a profession? 30,000 or so of TREB agents of the 70,000 sold nothing last year as per REM magazine. Anything being looked at? That's an interesting point you raise,
Well,
something that is mirrored in many
You know,
other.
and I think, David, it goes to, you know, from time to time, there are suggestions that, you know, individuals, what they can do on their license, for instance, there should be a time requirement for being licensed, like a graduated license that has a time requirement. But what you point out, David, really does illustrate some of the difficulties with those types of things. If I can't be a broker for 2 years experience, but during that 2 years I haven't sold anything,
Yeah.
or you know, so yeah, having time requirements isn't a complete answer.
Thank you for that comment. Jeff Taylor, public consumer confusion. I'm not sure what that refers to, but thank you for that comment. I have my condo management and regular real estate property management.
Yeah.
I already hold 2 business cards. There you go. Yeah.
Yeah,
That's the issue.
Alan already has so much room for cards, I guess, that.
Is it the same card or 2
It-
cards?
it-
I've seen that too. I've seen the same card with where you just flip it, it's
Different
mortgage.
size.
The other is real estate, so you can see both.
Thank you, Alan. And I think we dealt with Dale's.
Yeah,
And then,
please give us contact info. Oh, it's in the chat. And do they have access to that chat? Perfect. Can someone who has been licensed for 24 years and holds all licenses be grandfathered?
I think that the
That's the
thought,
match.
Tracy, the thought that the industry councils have been looking at and I've been told that I should try to come up with a different word from grandfathered. So I thought legacied. So the thought is, and the committee's recommendation was that to the extent that those sectors come in, that individuals currently holding those would be legacied, so that they would continue to be able to opt in to the sectors that they currently hold.
Len says, I agree. I just had an Ontario licensee in mortgages as a level 2 years experience, but never done an actual deal. Thank you for that comment. I miss Brett's up top. He says, all those non-trading licensees paying fees to a regulator and associations keeps the fees low for trading realtors. It's an interesting point. Do consumers care if someone doesn't trade? Not a problem, in my opinion. Thanks for that, Brett. Competency comes with repeated action and behavior. So volumes could be a predictor of competency. Brokerage doing 3 deals a year versus 20. So there's truth in that, but I guess on the extremes of that, I've seen some people that do a lot of deals and are not very competent, and people who do very few deals and are very diligent in terms of how they do them. So I don't think that's always the case, but I guess the exceptions to the rule aren't a good argument. Alan, thank you for that comment though. I like the legacy idea for those who are already fully licensed in various sectors.
Yeah, and then also, and the same 3-year period would remain. So if individuals choose not to be licensed in a certain sector, well, then they would have a period of time. They have a period of time that they could come back into the industry without further education, other than some pre-licensing education, or sorry, relicensing education. If there's been continuing education issued since, then those coming back into the industry would have to get it. And thank you, Alan. The amount of gray hair that I have, I'm looking for any Alan said senior citizens continuation rather than grandfathering.
David says realtors using listings for lead generation logically, but buyers not getting best representation. And I have no idea what they're doing and divulging too much info right away. Individual representations makes the most sense. If RECA there is there to protect the public. Sorry, but I cannot show you my listing as I represent the seller. Anything you say or divulge can and will be used against you in a negotiation. Thank you for that comment, David. Next we have Annie. That makes sense. Thank you for that. Rachel, I feel like the legacy idea would be a nightmare for the licensing department. Might be confusing for the public also. Thank you. Tracy, I thought that a brokerage license with RECA can only trade in the name of the brokerage. Example, owner of a real estate firm in Alberta is licensed, but not broker, are not advertising and answering phones in the owner's name, not that what is licensed with RECA.
Maybe contact Christian
Tracy,
on that one.
We can chat.
And then Lauren, also the issue of competency comes from repeated actions and behaviors. So volumes can be a predictor of competence. That's definitely true as well.
Thank you for that. We have some raised hands.
I think you can only just
Type the comments.
type the comments or the questions. Yeah.
Thank you. This was good. Thank you for that.
Thanks, Anne. And again, if there are any other things that individuals have thought of after the session ends, we've put the contact information in the chat, and so there's the general consultation email, and Christian's email is also there. But we really appreciate anything that you can provide in feedback that assists the committee and then subsequently the industry councils in making their decisions on how the best way to proceed is. Well, seeing that we don't have any more questions right now, Neil, did you have any closing remarks before we move on?
Just that I'm impressed with the way you're dealing with these issues and the input you're getting from everybody that are prepared to participate. I think this is healthy for the future rules that we come up with.
Thank you, Neil.
Thank you so much, Neil, and thank you for that comment, Dale. As one who's new to the industry, this was very helpful. Thanks. It would bring less money dues into RECA, area, CREA, RAY. We already have too much duplication from boards and association industry, as it seems everyone has. Can we not amalgamate some of this? Corey, that's an interesting point you raised. So maybe message me after if you want to chat. This was
No problem.
yeah. Feel free to contact me directly about the comments I made about condo management. Really appreciate it.
Thank you, Dana. I'll reach out and hopefully we can touch base. And thank you, Steve. Alrighty. Well, thanks everybody for attending. Christian, do you have any closing remarks as the moderator? You did a great job.
Thank you so much, everyone. This has been an amazing discussion. I really appreciate as somebody who's been in the industry for a while. It's very it's a lot of fun to participate in this. So thank you all for the great comments and all the participation. And make sure you go through discussion paper number 3. I think that's coming soon, Brian.
Yeah,
Soonish, he says. But
trying our best.
It's going to be out there. Oh, thank you, Rachel. And oh, yeah, great question. Thank you so much for joining.
Thank you. Bye-bye.
Thanks. Bye-bye.